If you've been arrested for drunk driving, the first call you need to make is to attorney Ted Morgan. You can't afford to go it alone. You need to know your rights. You need someone with the experience to put your DUI behind you. 7 days a week, 24 hours a day. Call 706-317-5733. Ask for Ted.
Call Ted Morgan Law when you need a lifeline.
Hey everybody, welcome back to an all-new episode of DUI Law, Real Talk with Ted Morgan. I'm your host, Mike Leon. Ted is a seasoned Georgia trial attorney who has spent the last 30 years defending drivers in DUI and criminal cases in the state of Georgia. And in today's episode, we're focusing on what happens to your license after a DUI arrest and what the law actually says about penalties in the state of Georgia. So Ted, first off, good to see you. And after someone gets arrested for a DUI in Georgia, what's the first thing that they need to understand about how the law works?
Mike, thanks for having me. This is a real privilege again to speak to everyone. So in Georgia, and I can say in Alabama as well, depending on what you do the night you are arrested, the day you're arrested, it can be a very tight deadline coming on a license suspension. Real quick, if you refuse what's called the chemical test, then typically you're going to get another piece of paper that puts you on a tightrope of about 30 days. And if you don't take the proper action within that time, then your license in Georgia can get suspended for 12 months and there will be nothing anybody can do about it except beat the DUI to terminate that suspension. Whereas if you proactive, don't sit around and mull over this for days or weeks, go find a good DUI attorney, bring them all the paperwork, and we can handle it.
Ted, can you expand a little bit further? Explain how the court case and the license suspension process part of this, how they work separately in this Georgia DUI.
So it is interesting, Mike. In Georgia, like I say, you can be on a tightrope the night of arrest for what is really an administrative suspension. It doesn't wait on the DUI case. And in fact, it really doesn't care what's going on in the DUI case unless the DUI is dismissed or reduced to something other than a DUI. And the same thing on the criminal side, they're not really too concerned with what's going on in the suspension case. There are times when certain things you might do in the suspension case, the prosecutor could be interested in, but in most courts I go to, the criminal case is operating on its own plane, and so you've really you can't have two cases going on at the same time that we're maybe talking about the same set of facts, but the outcome of one may or may not affect the outcome of the other. So it's a little more complicated than I think a lot of people realize, and that's why a good DUI lawyer is critical.
Critical because, there's this process on the administrative side with the license versus what the actual case is happening in court. So is it true? I'm assuming then it's true. You can lose your license before you even go to court.
Oh, absolutely. You can in Georgia. And I know because I practice in Alabama as well, Mike, it's a very similar process. Like I say, if you have the license suspension case going, and that's not every DUI, but it's a simple question. Did you refuse the chemical test after you were arrested? They generally read you your implied consent advisement, and they ask you for another test. And if you refuse that in Georgia or Alabama, that's when the officer he's basically required to initiate an administrative case. And so, yes, that case can reach conclusion really quickly if you don't hire a lawyer. But even if you do, that case is probably going to come to a head and reach a conclusion on your license much quicker than the criminal case. And yes, in some cases, that means you might be suspended. But, in our practice, what we do is we try to really manhandle the administrative case. And we do have ways, fortunately, in most cases of saving you on the administrative side. You might take a hit or two for that we can talk about later, kind of beyond the scope of this question. But yes, you can lose your license very quickly without the criminal case, without even going to court.
Ted, I heard something about a 30-day rule work. Like, can you kind of explain what that is and what happens if somebody were to miss that deadline?
So yeah, that's what we're talking about, Mike, on the administrative side. Georgia changed it. I guess it's been at least 5 years, probably more. It used to be a 10-day window. Now it's 30 days. And what they do is, again, if you don't take that chemical test and the officer issues what we call DDS 1205, because that's just the form number DDS puts on it. It's nothing magical we came up with. But we always ask the driver, hey, did you get the form 1205? And if they did, then we know we've got 30 days from the date of the arrest to file a request for a hearing. You file a request for a hearing to slow the train down, because if you don't, then Georgia's law says if you miss the 30-day deadline, then on day 45, technically, you are suspended. And your suspension is different depending on what you said or did. If you refused, then it's 12 months. If you took the test and you were over the limit and the officer has that result on the night of arrest, he can still give you the 1205 and you still have the 30-day deadline. It's just your consequences can be a little less harsh because you took the test. That's not to say I encourage folks to take the test, but that's just how it works out.
So many intricacies, right? That's why you hire, a seasoned DUI attorney. Ted, let me ask you, because we were talking about the license process before. So can you kind of give the consequences for people that maybe get a first-time DUI offense versus second and third time?
Sure, Mike. And that's a great question, because and look, I'm just going to answer this question in terms of being convicted of DUI on the criminal side. As we've gotten into, there is an administrative license suspension case that may be present as a result of what you did or didn't do on the night of arrest. So, and those license consequences can be a little different. For instance, if you're convicted as a 1st and 5 administrative suspension, that one, you don't get a limited permit if you refused the chemical test. Whereas on the criminal side, on the first DUI conviction, even though it is a 12-month suspension, in Georgia, you have immediate eligibility for a limited driving permit, which in Georgia is a good one for a 1st and 10. Okay, and so you stay in that for 120 days, and then you can fully reinstate your privileges as long as you hadn't committed any other party fouls, as I say, and jump through a couple more hoops. But as you progress, your 2nd in 10 conviction on the licensing side, now it gets tougher. It's a 3-year suspension. You do have some eligibility to reinstate early, but only after 18 months. And the first 4 months, the first 120 days, you're going to be on the bench with nothing, no limited permit. And then you have to, between day 1 and 18 months, you have to go get an ignition interlock placed on your vehicle. Then you get the ignition interlock permit, and you stay in that for 12 months. That's the only way you're going to get your license back at all, but it's also the only way you're going to get it back early. That and a reinstatement fee. You always have to take in Georgia, what we call the DUI, alcohol or drug risk reduction program. That's a long course. It's expensive. I don't recommend folks go jump and do that immediately after arrest, because you might not be convicted of DUI, for one thing. But yeah, and then your 3rd DUI in 10 years, your licensing probably is going to be affected. It gets into, though, Mike, on the licensing side, the look back is 5 years. So while you may have a serious criminal case as a 3rd and 10, it might not be your 3rd and 5. Hopefully it's not. But yeah, if it is, then your licensing, then you're an habitual violator. You're losing your license for probably 5 years.
Ted, can you expand on, I guess, the misconception of like, if you get a DUI, it's going to mean for sure a full suspension. But you just mentioned kind of limited and restricted licenses. Kind of expand on that a little bit, because I think the misconception is if you get one, you get convicted, you're going to get a full suspension. And that's not the case from what I'm hearing.
Yeah, that is right. You probably still need legal counsel to get you through this so that you just know what your options are. But in Georgia, generally, if it's your first DUI conviction or suspension for DUI, I'll say in 5 years, and we don't want to get into this too deep, but there are other things that can disqualify you from this besides a DUI. But let's just say nothing other than a DUI first in 5, then you are eligible for a limited driving permit, and you stay in that permit for 120 days. The permit is, in I guess the simplest terms, you can't run personal errands, but you to and from work, to and from anything the court orders you to do as a result of your DUI. In other words, the court sentences you to go to the DUI risk reduction program. You're good to drive to that. So to and from work, and pretty much, I would say, even if you drive for work. The exceptions could be CDLs, how that all affects your CDL, but just for purposes of limited driving permits, it's pretty good. And then, but your second and third DUI, your limited driving permits are kind of what we talked about earlier. It's the ignition interlock permit. It changes from the first to the second, but there is a good opportunity to get that limited driving permit. And one more thing on that, Mike. Something we kind of touched on is that the one critical thing a good DUI lawyer can do for you is avoid the pitfall of getting suspended on the administrative side, where you do not get that permit if it was what we call a refusal case. That same refusal case, if you have to take your hit, you take it over on the criminal side because for whatever reason, Georgia does give you the limited permit if that's the way you come into the driver services with a conviction. It's a crazy anomaly, but it's a well-known one to the DUI attorneys that handle this stuff.
Ted, you were mentioning earlier in the episode about the sobriety test or field test. So let me expand on that for a second and ask you, are license penalties different if you refuse that breathalyzer or blood test?
So great question. A lot of misunderstanding about it. There are field sobriety tests. The officer pulls you over. There's a phase 1, phase 2, phase 3, we say. But during the phase 2, during his investigation, typically in Georgia and a lot of states that have adopted it, I'll say, we have standardized field sobriety tests. Those are typically going to be HGN, with horizontal gaze nystagmus, where they test your eyes. And they're testing for nystagmus. In other words, the inability for you to hold your vision out to the side, let's say, and not wiggle. Your eyes don't wiggle. Then you've got a one-leg stand, exactly what it sounds like. You stand on one leg, the other one's 6 inches off the ground, and you count. The officer's basically seeing if you can get to 30 seconds without putting your foot down and without falling down. Then you've got the walk and turn. Walk and turn is basically that's a tricky one because they tell you to stand at attention as he instructs you. Then he tells you not to start, and then he demonstrates the walk and turn. And if you start, then they that's a bad sign in their eyes because you failed to pay attention when he said don't start until I tell you to. But after that, they're evaluating your ability to walk heel to toe, typically 9 steps down, turn, and then 9 steps back, heel to toe. Those are the typical. And then there's one more, and this is where it gets confusing about how does the refusal affect. The portable breath test in Georgia is a little Alka sensor. And if you refuse that, that's not the chemical test of breath. That's just another field sobriety test. And you can refuse all the field sobriety, but it's after the arrest that then there's another test. And that's not a field sobriety test. That's a chemical test to convict you. when they ask you for that.
So let me ask you, because you mentioned CDLs earlier, which are commercial driver's license. How do DUI laws affect people that have that? Are the rules stricter for folks that have CDLs?
They are in a lot of ways, Mike. Generally, in most states like Georgia, you have two ways that you can be convicted of DUI. And one is we call per se, which is just fancy lawyer talk for we have a chemical test and you're over the limit. So Georgia says if you're 0.08 grams per liter of blood at the time you were driving, then you are DUI, 0.08 or higher. And so with a CDL, that's 0.04 if you're in a commercial vehicle. But then the other side of that is if I have a CDL, but I just go out to dinner one night in my car and I get a DUI, federal regulations are probably going to suspend your CDL license if you are convicted of DUI. So while your regular Class C license, your regular license may be treated just like we've talked about during this cast here, how you're suspended and whether you get limited driving permits, you still may have that in play, but your CDL may get bumped based on federal regulations that the state that you're in has to follow in order to have the CDL drivers, effectively on the road. So yes, they are definitely treated differently, definitely treated more harsh in terms of the real consequences. They can lose their CDL if certain things happen.
So much information, so many intricacies. Ted, somebody's listening to this. They're feeling overwhelmed. They're confused. They just want to keep their license or even maybe get it back. What's your piece of advice to them?
Mike, what I see a lot, and I think I was probably like this before I started doing DUI law, is it's even in our how we talk about it. We say, what happened last night? I got a DUI. And it's almost like it's over. The case is over. I got a DUI. I was arrested. And I think what folks that get arrested need to really understand is that it's not over. There's a lot of things that can affect whether you are convicted, whether you can get a negotiated plea to something less than DUI, or whether your attorney can do what we call damage control. Sometimes the DUI may stick, but there's a lot of things, a lot of consequences that we can help you with to minimize that. And so don't just take the position that you're cooked, there's nothing I can do, and I'm just going to go down there and let them do whatever they do to me. Please call a good DUI lawyer and give yourself a chance.
Well, Ted, thank you for the insights and analysis on this, man. We truly appreciate it.
Absolutely, Mike. Thank you for having me. It's been a pleasure.
And thank you to everybody out there for listening to DUI Law, Real Talk. If you are facing a DUI right now in the state of Georgia, you're worried about losing your license, don't wait. Like Ted said, contact an attorney. I got one right here with me, tedmorganlaw.com. Schedule a consultation right now with Ted. Be sure to like, subscribe, leave us a review if today's episode helped you, or send it to somebody you know that needs the help. As always, I'm Mike Leon. Thanks for watching, everybody.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.